This
does it very
conference will
awkwardly.
now be recorded.
It does it kind of awkwardly, but that's what it's for. It's to ensure fair housing access throughout the Commonwealth for people who are lower moderate income. Affordability is defined by income limits that are actually established by the U.S. Department of Housing and Urban Development. These are federal income limits. Most states simply adopt them for their affordable housing laws. They're always based on regional incomes, not local. And the reason for that, again, if you think back to affordable housing being kind of a regional need, then you would certainly want to account for kind of the regional income situation and not just that of a locality. And I guess the best example I can give you is a town I worked in. I had the privilege of working in Wellesley a few years ago on their housing production plan. Well, as you probably all know, Wellesley's one of the wealthiest towns in the Commonwealth. So if you base the income limits for affordable housing in Wellesley on that town's own income situation, you would essentially make it impossible for people elsewhere in the Boston area to afford the housing in Wellesley. So you're taking a regional median income and percentages of that define what it means to be eligible for affordable housing. And they're based on the metro and non-metro areas that you find throughout the Commonwealth. The scope of a comprehensive permit is all local regulations. Anything that a developer would normally have to go and apply for somewhere, whether it's to the planning board or to the Conservation Commission if there's a local wetlands bylaw, or to the Board of Health if there's a Title V issue involved. All these kind of local regulations that are typically the province of various town boards are subsumed by the comprehensive permit. And the Board of Appeals finds itself in this role that only happens with a 40B, where all of a sudden they're expected to be able to interpret, administer, apply regulations that normally do not fall within their bailiwick. Boards of appeal that do a lot of special permit work, it's a much easier step into comprehensive permits because they're used to plan review. But a lot of Board of Appeals, I mean, these are just things they normally don't deal with. So this is why you're going to hear me harp on this in a little bit, the importance of other town boards and staff helping the ZBA to make this project work and get the best project that you can for your town. When a developer feels that he or she can't meet some of your local regulations, it's their burden to request waivers. And so part of the comprehensive permit application is a list of things that the applicant wants you to waive. So if you have a subdivision requirement around, the width of a road or a maximum length of a cul-de-sac or whatever, the developer is likely to ask for a waiver of those things that from the developer's perspective make it difficult or impossible to build the project that he or she wants to build. So these are all the things that the Board of Appeals has to consider when reviewing a comprehensive permit application.
Judy, can I interrupt for
sure, I was going to stop in a second anyway. Go ahead.
Oh, no, go ahead if you're going to stop shortly.
Yeah, so just not within the ZBA's purview. So I've told you the things that are in the ZBA's purview: zoning, subdivision control, et cetera. But there are things that are not. And one is the board really can't consider what often comes up, which is how is this going to affect our schools? Do we have enough school space or some other public service? Those things are not within the ZBA's purview. The ZBA can consider, however, impacts on infrastructure if those impacts are directly related to the project. Can I get water safely to this site? Things like that. Fiscal impact studies, no, they do not belong in the comprehensive permit process. The board does not have jurisdiction over any aspect of the tenant or home buyer selection process. That is handled by the subsidizing agency at a later phase. Monitoring profit is not within the board's purview. That is handled by the subsidizing agency at a much later phase. A market study also is not within the ZBA's purview. That is handled by the subsidizing agency. So there are things you can do. You have actually have significant authority under this law because you're subsuming all these local regulations. But there are certain things that you can't consider. And if you just think about, well, if this were a subdivision in front of the planning board, could the planning board turn down a subdivision because people think that there's not enough space in the schools? Or can the planning board turn down a subdivision because someone thinks there's going to be a negative fiscal impact? Well, the answer is no. So given that, you have to kind of think about, I can't impose on a comprehensive permit some expectation that I can't impose on some other project. So I think it's sometimes helpful to keep that in mind as well. So Karen, were a couple of questions there you wanted me to respond to?
Yes, there was one question.
Sure.
So, is there a way that prior performance of an applicant can be considered in the comprehensive permit process?
I think it would be very hard for the Board of Appeals to do that, because part of the subsidizing agency's responsibility during project eligibility is to consider the capacity of the developer. I mean, they should be looking at that. I would say no, although I would certainly think the board may want to put some conditions on the applicant, if reasonable conditions, if there's a concern. It's kind of a broad answer, but it's a broad question too.
Right. Thank you. That's it.
Okay, all right, I'll keep going. Well, what is the Housing Appeals Committee and what do they do? That is an entity that is created under Chapter 40B to handle appeals from developers who are aggrieved by the decision of the ZBA. They have the authority to uphold the ZBA's decision or overrule it in some way. They can, remove some conditions. They sometimes can add conditions as well. But the role of the Housing Appeals Committee is to attempt to try to resolve disagreements between the board and the applicant without necessarily having to go to court. So any community where the existing subsidized housing inventory is less than 10% of the year-round units in that community, the developer has the option to go to the Housing Appeals Committee if he or she is unhappy. Once you're over 10%, that ability goes away, and now the developer would have to go to court just like anybody else. What the HAC looks at, and I think it's important for the boards to understand this too, because it might help you in thinking about how you're regulating a project or how you're handling the permit process and the decision-making effort, is to what extent is the decision of the board consistent with local needs? That doesn't mean necessarily local housing needs. It means things that are defined in the statute as valid local concerns. Public health, public safety, open space, design, and environmental impact. Those are the key local concerns that are defined in the statute. And if you think about it, these are all things that kind of you might look at anyway in some other development that's not a 40B. Are there public health issues raised by the project? Is access to this place safe? Is circulation within it safe? Is there a reasonable provision for open space within the site for the enjoyment of the residents who will live there? How does this proposed development sit on the site, and how does it relate to what's around it? Are there ways to make a kind of large or bulky project that's different from the buildings around it fit on that site? And what kinds of things could you do through perhaps redesign, modifications to make it fit better? Environmental impact, we always look at wetland impacts. We think about stormwater. These are all things that any board would consider in a development review. And essentially what the statute is saying is, you know how you do these things anyway? Well, these things are okay for you to consider as local concerns. So the board in the end has to make this really difficult decision under a law that is intended to produce housing. And that's the whole point of 40B, is to produce housing. So I have this regional need. I'm not at 10%, so I haven't met my burden as a town for my fair share of that regional need. Are the local concerns that I now want to use to impose conditions on this project, are those more important or more substantial than the regional need for affordable housing? And those are the things that the board has to balance in making its decision. And the Housing Appeals Committee will certainly look at that in an appeal. So what's the subsidized housing inventory? That is, as you probably all know, it is the roster of the affordable units in each city and town. And it is the official list that determines whether a community is at or below 10% of what we call that's statutory minimum. It's 10% of your year-round housing units being affordable or not. It includes units created through comprehensive permits. It includes units created under what's called a Chapter 40R overlay district, which some of you may be familiar with. We're not really going to talk about 40R tonight, other than to acknowledge it's another way to create kind of higher density housing through a local zoning provision that you work through with DHCD and approve at town meeting, and then you can do as of right multifamily development. Or other types of, quote, local action units approved by DHCD, which could be housing that's created because you've given Community Preservation Act money to a project, or you've got a zoning provision that gives a density bonus in exchange for affordable units, and now you've got those affordable units, you want to get them on the SHI. Local action unit process is a way to do that. And then, understanding too that in the SHI, there are some different rules that apply to rental or ownership units. Again, you may all kind of already know this, but I don't know if you do. So I'll just explain that if it's a rental development, at least 25% of the units are affordable to households with incomes at or below 80% of the regional median, then all of the units will count on the subsidized housing inventory. If it's an ownership project and has that 25% threshold, which is really kind of the key to eligibility for a comp permit anyway, in ownership projects, only the affordable units count, the actually affordable units. But if it's a rental project, all of the units will count if the project meets that 25% threshold. There are things that can really help the ZBA through this process. One is a strong chair. Doesn't necessarily have to be the regular chair of your board. Most ZBAs I work with will sometimes rotate responsibility for chairing public hearings because it's a burden. So whoever's like really strong and confident at managing a hearing is probably the best choice to manage the comprehensive permit. My experience is that the more people get the sense that the board is in charge, in command, and managing the process, the more likely it is that things are civil, they're productive, and frankly, you're probably going to end up with a good project. Another thing that I think is just critical for these boards is support from town staff where town staff exist. If there's a town planner, having the town planner involved, even if the planner normally doesn't work with the ZBA, having help from the town planner, going to the MHP Technical Assistance Program, or help from the town council or city solicitor, they should really be involved, especially at the end when the decision is being drafted, because if there's going to be litigation, town council ought to see it before it gets filed with the city or town clerk. I think also having a working relationship with the planning board, the conservation commission, these other boards that typically get involved in reviewing development projects, who may never normally kind of work with a ZBA, but a ZBA that has a relationship with these boards is likely to get help, support, and assistance and cooperation from other boards that kind of know they have particular expertise and particular kind of jurisdiction, especially when you're trying to review the request for waivers. Having conservation and planning involved in being able to answer the question, not should we waive these things, but is there a substantial impact that just can't be mitigated if we waive some requirement? Getting that input from those boards can be very helpful. Comprehensive permit training for the Board of Appeals. If it's a board that's recently done one of these, they're probably fine. If they haven't seen one in 10 years, they probably should get some training because a lot of things have changed. Access to peer review consultants. I will talk about that a little bit more later, but having peer review support is just key. I don't care who's on the ZBA, they need independent, kind of neutral outside help to review these applications. And so having consultants hired at the developer's expense, but hired by the board to serve the board's needs makes a big difference, especially if they're not getting much help from other town departments. And then also, a developer who'll go out and meet with the neighborhood, maybe try to work some things out with the neighborhood. You can't require that, but boy, it really does make a difference when the developer is willing to go out and work with the neighborhood and maybe try to resolve some issues with the neighborhood before the comprehensive permit process ends. That can often lead to some changes in the plan that the neighborhood might be happy with or at least comfortable with. that might make it then easier for the ZBA to complete the comprehensive permit process and issue a decision for a successful development. Just a little bit about the project eligibility. Is there a question, Karen?
Yes,
Okay.
I wanted to get it before you moved on to this part.
That's fine, go ahead.
So it says, we are having numerous 40Bs. Most are not addressing our housing needs because the units are ownership and our plan ownership numbers were already met. We need rental, but ownership keep coming before us. Is there an answer for this situation?
It's really something that needs to be taken up during the project eligibility process. That's really where to direct it, because the subsidizing agency is going to issue a decision for a project. And if there's a real issue with a project that's not meeting local needs, it's probably a good idea to make sure the subsidizing agency hears that. One of the things they will look at is, what have you done as a town to try to address those local needs in your plan that may not be being addressed for whatever reason through the comprehensive permit process. Do you have, for example, a 40R district where rental development was created? Do you have an inclusionary housing bylaw that has enough of a density incentive in it to make rental development feasible? Have you put local funds into a project to increase the feasibility of rental development? I think when you've done those kinds of things, when you've taken those steps to implement your plan, it becomes a lot easier for a subsidizing agency to say, okay, we get it. That really is what your need is, and you're trying to meet it. Maybe we won't approve this project, or maybe we'll work with the developer to try to make it rental. That may not be a satisfactory answer, but I think just put yourself in the position of the subsidizing agency. Their mandate under 40B is to get housing built. So it's fine for the community to say, but that's not what we need. If I were on the subsidizing agency, I'd say, so what are you doing to make those needs be met? What have you done? And take it from there. So if you think there are needs that are not being met, think about what you can do as a community to try to make them be met, perhaps outside the comprehensive permit process.
And there's a follow-up question to that. Is that the responsibility of the planning board?
Oh boy, it's a good question. I mean, well, because every town I've worked in is so different. I mean, I've worked in towns where there's a really effective affordable housing trust, and they're out there making stuff happen. They have money. They're putting it into projects that meet what they consider to be local needs based on the housing production plan. Maybe they're only putting their funding into rental developments because that's what they think they need. A planning board is probably a logical place to have a conversation about changes in zoning to make affordable housing happen. But I think that the part of the real difficulty for the boards is for the zoning, to use zoning or anything, but particularly zoning, to try to create housing that you think meets your needs, or that does meet your needs. I'll just leave it at that. The zoning has to work. And if it doesn't work, then the needs don't get met. So there's a lot of reality check that I think has to happen in these local efforts to address needs that are identified in a housing plan. The other thing I will say is that sometimes housing plans, because they go through a political process themselves, will identify needs that may not be feasible to meet in that market without tremendous local support and money, frankly. And so doing a reality check on, here's what you want, here's what you think you need, what's it going to take to make those needs be met, is terribly important. And I would be the first to tell you, comprehensive permits do not necessarily address local need. They are intended to address regional need.
Do yours again?
Another one, Karen?
Sorry.
Okay.
What about climate change? That was in regards to the local concerns, I believe.
That's kind of a broad question. I'm not quite sure what the issue is. If, I mean, clearly, if a site is adjacent to a flood zone, if there's an impact on wetlands, let me just say this, the developer has to comply with state law, has to comply with state regulations. So any kind of environmental impact that is regulated at the state level is going to be handled through a state permitting process that's separate from the comprehensive permit. I don't know how else to, it's just a big question. I'm not quite sure what to do with it. If maybe somebody could provide more specifics, I might be able to give a better answer.
Okay, that's all we have for now.
Okay. So this pre-qualification process that I was just alluding to is when the developer goes to one of the subsidizing agencies and files an application for what's called project eligibility, which is sometimes called site approval. And those agencies that are listed on the slide are typically the ones that the developer goes to. Mass Housing is probably the most common one. Mass Housing Partnership is also a subsidizing agency and does reviews of projects before they go to the Board of Appeals. Mass Development doesn't do many, but I see them once in a while. And then DHCD has the tax credits program, administers the local action units, local initiative comp permits. So they all have a role to play. The developer is going to go to one of those agencies to request project eligibility. And that has to be granted before the developer shows up on the doorstep of the ZBA. There's an application protocol for the project eligibility application. It's awfully similar to what goes to the ZBA, although the ZBA application would include some additional things. But you know, you're filing an application to say, here's my site, I want to build X project on it, what do you think? And so they have to kind of tell you, where's this located? Tell us about the site. There needs to be a locus map and pictures so people can picture the site. What are you proposing to build? How many structures? How many units? What type? Kind of what size? What's the program under which the developer is seeking a project eligibility approval, because there are different housing programs administered by those agencies. They have to provide what's called a preliminary development pro forma, which is basically the developer saying, here's why I think this project will work. Here's how I know this thing is feasible, and my profit will end up being within the constraints of the program. Just basic details. How many low and moderate income units are we talking about? At what income levels? What kind of affordable housing restriction are we talking about? 30 years of perpetuity? What's the applicant planning to do? And what type of applicant is this? Applicants for a comprehensive permit have to be one of three types: a public agency, like a housing authority, a nonprofit entity, like NeighborWorks, or what's called a limited dividend organization, which is a for-profit developer that agrees to limit its profits under the terms and conditions of a housing subsidy program. There needs to be a site plan. Of course, this is not a fully engineered drawing. We're not in the final permitting stage yet, but a plan showing the layout of the site, basic elevation drawings, you know, what kind of buildings do we think we want to build, and basic site development calculations. How much of the site's going to be covered by impervious cover? Where's the open areas? How much of the site is actually open? How many parking spaces are we talking about providing? What are these buildings going to look like? What's the massing? What are the kind of materials will be on the exterior of the buildings, and how do they relate to surrounding properties? The waivers that the applicant thinks are going to need from local regulations, and of course, critically, evidence of site control, which is, do you actually control this site? Do you own it? Do you have it under a purchase and sale agreement? This is all the stuff that the applicant has to give the subsidizing agency. And again, it is very similar to what will eventually be submitted to the ZBA for the comprehensive permit. So there's this process for the PEL. The application's filed. The agency receiving it notifies local officials that this application's been filed. The agency will conduct a site visit. There is a 30-day comment period for the town or city to provide comments back to the subsidizing agency, and then eventually the agency will make a decision, which may or may not be favorable to what originally was filed. I've been involved in a couple of these lately with a town that's about to get hit with several 40Bs, and one of the things that I've seen, that probably more than I've ever seen before, is the extent to which the particular subsidizing agency has pushed back and required some changes from the applicant in order to get to the point where the agency would give a favorable decision. So a lot more goes on in that project eligibility process than I think sometimes communities see. The agency has to make certain findings to grant that PEL. You know, does this project seem generally eligible under the guidelines of our program? Is the site generally appropriate? And, you know, people kind of ask a lot of questions about that. I think it's important to remember that in Chapter 40B terms, land zoned for residential, commercial, or industrial development is potentially appropriate for housing. And then what is the design of this project? What's this thing going to be? How big is it? Does it generally make sense for the site? These are all, I would say, pretty general statements here that sometimes probably drive local officials crazy. But again, bearing in mind that the job of the agencies ultimately, why do they have housing subsidy programs? It's to get housing built. So the perspective of the agency is going to kind of always be, if there's a way to make this happen that's appropriate, then the PEL is probably going to be granted. And the other thing that I think the agencies are very sensitive to is not stepping into the role of the ZBA. So the agency is basically making this threshold determination. Does this thing make sense for the site? Is the site generally appropriate? Does this thing seem feasible? Is the applicant eligible? Does the applicant control the site? Just basic things that are required under the statute and of sufficient information at this stage of the game for someone to say, you know, if the local board of appeals gave a comp permit for this project, it probably would get built. It's probably feasible. It looks like it makes sense to us. So those are sort of the findings that the agency has to make. And ultimately, if they're able to make a positive finding for all of them, then they will issue that project eligibility letter. I have never seen it come out within like 30 days, except for a few local initiative program comprehensive permits where the town really wanted the project. But it just, there's a lot of back and forth that goes on. And also, the agencies need to have some sense of what the property is actually worth. Otherwise, the pro forma is kind of meaningless. So one of the first things that they do, at least in my knowledge, is request an appraisal so they have some idea of what the site is worth. So that can take time. Just getting the appraisal done can take time. Karen, is there any question that's come up that since you and I spoke before I get into this next section?
Nope.
Okay. So I want to talk about the hearing process. You will save a lot of headaches for yourselves if your Board of Appeals has administrative 40B regulations that are substantially consistent with the state regs, but you have your own regs and you do things in your regs that the state regs don't do. Like one of the things you really should do, I've seen this problem over and over again, have an application that's geared to the comprehensive permit. So you tell the applicant, like, this is what we need you to submit with your application. So you might have, say, an application cover sheet that establishes what the project is, gives you basic information, and an attachment that lists all the stuff that you're expecting the applicant to provide. Because chances are they're not going to go back and read your administrative regs, and the building department's probably not going to go read your administrative regs. But if the application makes it clear what the applicant has to submit, it's just a helpful way to communicate with your prospective developer. So part of the adoption of the local regs is to actually design your application form, and don't assume that your special permit or variance application is going to do it for you, because they're all these applications filed under these different statutory schemes all have kind of different masters, if you will. So it's really important to make sure that you're communicating with your comprehensive permit applicants what it is that you expect them to provide, obviously within the context of the board's authority. Tell the applicant how to apply and what information you need and how you're going to process that application once you receive it. So just basic procedures in your regs. Who's going to run the hearing, or not by name, but just, you know, if someone from the board is going to run the hearing. How many people are voting members of the board? Does the board have associate members? Is this a town that's adopted the Mullen rule? So if we lose a member, we can replace them with somebody, or we can have someone listen to you know, minutes of the recording of the hearing and join if they've only missed one meeting. Just the regulations really can be so helpful to you as a ZBA, to other people in town hall who don't know what you're doing, but then also to the applicant. So much about this process can go better if people simply communicate clearly what their expectations are and treat the process fairly. The statute identifies three thresholds, if you will, any one of which, if you exceed it as a town, essentially means you've met your regional fair share. So if you're under any one of these, if you're over any one of these, you would be able to say, if you chose, we're going to deny this application, and that is consistent with local needs, our public health, public safety, environmental, and so forth. Those needs can outweigh this regional need because we've met our regional need. So the one that everybody's the most familiar with is this concept of the 10%, which is based on the most recent decennial census. So the denominator is updated every 10 years. The numerator keeps updating as you grant comprehensive permits. So that's how communities might start a decade at 5% and end up at the end of the decade at 8%, because they've been granting comprehensive permits or otherwise creating affordable housing in the interim, but all the while the denominator has stayed the same. As soon as the Census 2020 housing counts are released, DHCD will eventually update the subsidized housing inventory to replace the existing year-round housing count with the new one. And what happens at that point is many communities that are at 10% may fall down below 10%. Clearly not all of them, but some of them do. But 10% is the most commonly kind of recognized standard. And it really is sort of the way of saying, yeah, we've met our regional need. The other threshold that I think people are increasingly familiar with is this concept that even if you don't have 10% of your housing as affordable and listed on the subsidized housing inventory, if you count up all the housing that you have that's on the SHI, say you're at 7%, and you count up all the units that comprise that 7%, and you look at the land that's used by those projects, the land is consumed by them. If the sum of that land area is equal to or greater than 1.5% of the total land in your town that's zoned for residential, commercial, or industrial use, then the Board of Appeals can say, we don't have to approve this comprehensive permit because our town exceeds that 1.5%, what's called general land area requirement. There's a lot kind of going on about that. Some of you are probably familiar with it. Some boards have attempted to make that argument and had sort of trouble doing so. The DHCD guidelines for the 1.5% general land area minimum can be kind of difficult to meet, but I just want to acknowledge that that opportunity exists, that even if your town is not at 10%, you might meet that 1.5% rule. And then the third way a board could turn down an application and be considered consistent with local need is that if a project is going to disturb what's 0.3 of 1% of the land that's, again, zoned for residential, commercial, or industrial use, or 10 acres, whichever is larger, in a single calendar year. That doesn't mean a 15-acre site could be bounced out, because what this is saying is the actual land that's going to be disturbed by shovels. Doesn't mean the area of the site. The second threshold does mean the area of the site. The third one is the actual area being disturbed for construction. So it's actually pretty hard to meet, but I mean, it is an option there. And so it's something that you should be aware of. But these are the three ways in the statute that a Board of Appeals could turn down a comprehensive permit and not have that decision overturned by the Housing Appeals Committee. Of course, a board can continue to grant comprehensive permits, even if the town exceeds these thresholds. We have plenty of examples in Massachusetts of towns that are over 10% that continue to grant comprehensive permits. So I don't want anybody to get the idea that somehow at 10% you just don't have to do anything anymore. You don't, but you can. After Census 2000 was released, in a time when a lot of housing development had happened at the end of the 1990s, responding to pent-up demand that sort of accumulated in a previous recession between 1989 and 1990, which most of you may not even be old enough to remember, but I do. There was a big hue and cry when the new subsidized housing inventory came out, and a lot of communities that had been at 10% suddenly fell below it because of housing development that had happened at the end of the 1990s. So DHCD, in an attempt to try to work with communities and make 40B kind of more manageable at the local level, created these other ways for towns to manage comprehensive permits, i.e. perhaps even turn some down, under these so-called regulatory safe harbors. And these got to go back to regulatory changes that happened in 2001, 2002, and they live on with us today. One is, does your town have a housing production plan? And if it does, are you certified? Meaning, have you met a certain numerical target for production in the previous calendar year? And if you have, under an approved housing plan, then DHCD will generally grant you what's called a certification of your plan, and that enables the Board of Appeals to either continue to approve comp permits or deny and not be overturned by the Housing Appeals Committee. There's another standard that is for towns that don't have a housing production plan, but they've produced quite a bit of housing. It's called the recent progress threshold. That is a higher number that has to be met for it to apply, but it is available to communities. It's generally 2% of your year-round housing base would have to be the number of new lower moderate income units that you created in order to qualify under the recent progress rule. Then there's this concept of the large scale project, which essentially says, based on the total number of units you have in your town today, meaning your total housing inventory, projects can't exceed a certain size. And it's all tied to how many units you have in your town today. So those large scale project caps generally range from 150 units to 300, I think, and then on up for larger cities and so forth. But the idea is that depending on how much housing your town has today, a developer really would have trouble applying for a project that exceeds the cap for your town. Each town has the sort of cap defined. They would have trouble going to the Board of Appeals and expecting an approval, because the board could say, no, wait a minute, we don't have to give you a permit for 300 units. Our large scale project cap is 150. And then there's this concept of related application. And the easiest way I can explain this is a developer goes to the planning board and files for subdivision plan, and for whatever reason that plan is denied. And the developer says, I'm coming back with a 40B. They just can't do that. There has to be a cooling off period of at least a year. Now, that doesn't mean if a developer comes to your town and wants a zoning change and you turn it down, that doesn't give them grounds, that is not grounds for a related application decision. But if there's clearly been a decision on a special permit or a subdivision plan or something unfavorable to the applicant can't just swoop back in with a 40B application. There has to be a waiting period of at least a year. I mentioned earlier that one of the reasons we updated the manual is that there have been issues with 40B deadlines that are different from special permits and variances and so forth. And there's a page in the handbook. If you don't have the handbook, it's online at MHP's website, and I think it's even on CPTC's, but or any of you can email me and I'll just send it to you. But there's a whole chart in there on these deadlines that you have to pay attention to as a ZBA. And the first is that as soon as that application comes in the door, which means it's been filed with the town clerk and with your board, get it out to other boards to review. Don't sit on it, get it out there so people can start to read it. You have to notice your public hearing just as you would under 40A, twice, two weeks in a row, 14 days before, and then the week before the hearing. So there's a two publication notice requirement. That's just like 40A, but here's the one that gets people in trouble. You must open the hearing within 30 days. Even if you think the application is not complete, open the hearing. Because if you don't, the developer becomes able to go to the Housing Appeals Committee and say, they didn't meet a statutory requirement, I'm eligible for what's called constructive approval. And you don't want that to happen. So no matter what you may think about the application, whether you think it's incomplete, whatever, open the hearing. You can deal with completeness and so forth in the hearing process, but open the hearing within 30 days of receiving that application. If you think you can deny the application because you think your town has met one of those safe harbors I mentioned earlier, certified housing plan, recent progress rule, or you think your town is over 10%, and the developer just didn't know that, you have to tell the developer within 15 days of opening the hearing, we think we can turn you down because one of these thresholds our town actually meets. The developer gets to say, oh, okay, I'll go away. Or, well, maybe I agree with you that you meet that threshold, but I'd still like to work with you through the comp permit process. Or the developer can say, I think you're wrong, and then DHCD gets involved. And DHCD reviews the town's claim, reviews the developer's response, and makes a decision. All the while that process is going on, this concept of having to kind of bring the hearing to a close within 180 days of opening it, that kind of gets told, that sits. So the clock stops ticking while that safe harbor dispute is being resolved. Let's say for the sake of this discussion that DHCD agrees with the developer. Now the developer's back in front of the Board of Appeals. The board generally has 180 days to bring that hearing to a close. I would be unethical if I didn't tell you, so I will. That 180-day standard is in the regulations. It is not a statutory requirement. However, the developers are all keenly aware of it. So what it does is it really puts the burden on the ZBA to manage the process carefully. Really, from day one, you need to be thinking about a schedule of the hearings and what kinds of issues you think you're going to want to take up at different hearings, so it's all kind of well-timed. So you're not waiting until the end of 180 days to say, oops, we think we need a pro forma review, because you may not get it. So having a schedule worked out early on in the process can really help the ZBA manage this thing so that you don't end up at 180 days in a dispute with the applicant, whether the applicant's going to agree to an extension of the hearing. Once you close the hearing, the board has 40 days to deliberate, reach a decision, and file it with the city or town clerk. And of course, after that, just like under Chapter 40A, there is a 20-day appeal period. So some of this mirrors 40A, but this I can't underscore enough. 30 days to open the hearing, no matter what you think about the state of the application, and 40 days to reach a decision and file it with the town clerk. So if you think about how does that compare to a special permit under 40A, as you probably know, if you're a planning board member or a ZBA member or town staff, you have 65 days to open the hearing and 90 days to file the decision once the hearing is closed. So these are shorter timelines. And the reason for that is that the statute aims to get affordable housing built. Content of the application is going to be kind of similar to what the developer had to provide to the subsidizing agency. One would hope that the plan is in a little better shape. They have to give you a preliminary site development plan. So this is not going to be as detailed as what you might normally be accustomed to getting through site plan review, say, with the planning board. But it has to be clear enough that you can kind of tell the layout of the site, you understand the contours of the land, you understand what exists on that site today, how that project's going to lay out, what the utilities are going to be, how they're going to be provided. You have enough information to be able to judge the basic feasibility of this project. There should be an existing conditions report. What's on the land now? What issues are associated with this site that perhaps the board should be aware of? Preliminary architectural drawings. The developer should give you sample elevations for the project, floor plans, just so you get a sense of what these units look like. Building tabulations, how many buildings, how many units in each. If the project involves a subdivision, the applicant should also file a preliminary subdivision plan with the comprehensive permit. There should be a preliminary utilities plan so you understand how water, sewer, or whatever is going to be provided to the site. The project eligibility letter from the subsidizing agency, and a list of requested waivers. These are just the basic contents of that application. You can, within reason, require some additional content in your own administrative regulations, but you have to be careful that you're not straying beyond the intent of 40B, which is a streamlined application process intended to get housing built. So the question you need to ask yourself when you're thinking about the contents of your application is, what do you need to know in order to make a decision? And think about it that way. When you send the application out for review internally, think about the boards who typically get involved in other types of projects, but then there's also some that will be kind of special for 40B. Conservation Commission, this is important because the site probably has some wetlands associated with it. If your town has a local wetlands bylaw, the Board of Appeals is going to be the one to decide whether aspects of that bylaw will be waived, not the Conservation Commission. The Conservation Commission will still review a notice of intent and issue an order of conditions under the state wetlands law, but they're not administering the local wetlands law. That is the ZBA's job. So getting their input certainly on any waivers that are requested under the local wetlands bylaw is really important. The planning board, which is very accustomed to doing site plan review and subdivisions, get their input. Board of Health is important, especially if there's Title V, because there's no public sewer. If your town has a design review board or city has a design review board, get them involved. The Affordable Housing Committee, whatever it may be in your town, some towns have a committee, some have a partnership, some have a housing trust. This is one of the ways in which the comp permit process is a little different. Get their input, because the board should know, how does this project relate to the housing needs of the community? Again, not that you can't turn it down because you think the plan doesn't meet your local needs, but it can be very helpful for the housing trust to shed light for the board on here's what our housing plan says our needs are. These are things that we need, and here are ways in which this project addresses them. Even if the project has other issues, there are still things this project's doing to address needs, assuming that is the case. And then certainly making sure that your department heads get their hands on this application as soon as possible. You particularly want to hear from police and fire, because public safety is a specific local need mentioned in the statute. So you want to make sure early on that they have a look at the plan, the building plans, the site plan, and you have the benefit of their input. And certainly public works in terms of anything from snow storage to stormwater and so forth. Whatever, if they happen to be the ones that administer the stormwater bylaw, you want their input. So get the plans out to any board or commission that can be helpful to the Board of Appeals. What's interesting? A lot of times I've gone to work with ZBAs where there'll be some perfectly pleasant residents who show up who have no idea how a public hearing is supposed to run. They have never been to one. They have no idea. So people don't understand, even though you think they should, that the whole hearing process is to consider an application that someone has filed. Therefore, simple things like the applicant gets to speak first for some residents can be very disarming. Like, well, why is the Board of Appeals not listening to us first because we live here? It's because the hearing is about the application. So the chair can do so much to kind of help the public work with the process by explaining up front, how is it going to work? How is this process going to go? What are the kind of rules of engagement? How do you address the board? How do you get a question asked or presented to the applicant? Explain all this up front, and I guarantee you it will make things easier. I actually, for my boards of appeal, I have a large poster version of this public hearing protocol that I will give them to post at the hearing if they want it, so that it's kind of up and, it's in the front of the room. I realize we're not having face-to-face hearings right now, but it's up in front of the room and people can see, like, right up front, this is how this hearing is going to go. And it's there at every single hearing. So if someone shows up for hearing 3 and wasn't there the first time, they're not walking in, with no sort of orientation. Anything you can do to orient the public as to how this process works is going to make it better for everybody. In addition to explaining the process, how's the hearing process going to go, a little bit of explanation of the law and the ZBA's job under the law can be very helpful too. I've seen some boards do a very nice job on this, so that people kind of understand up front, this isn't like a special permit. This doesn't have quite the discretion that a special permit provides. What is this law and why do we have it? And why is the ZBA the one who's in charge of it? Set basic ground rules. There's nothing that says you have to let somebody get up and go on and on and on and repeat themselves. You can set, especially if you have a large number of people showing up, you can certainly set time limits for public comment. You could encourage people to provide written comment in case the time limit doesn't work for their oral presentation. Schedule a site visit as soon as you can and explain kind of how that works with the open meeting law. and then set a continuance date and ideally set the schedule for the next few months. I can't underscore enough how important that is, because it helps everybody kind of plan their lives. It helps with the process of lining up peer review consultants. It helps the applicant kind of plan who they have to have at each hearing, because it's kind of silly to have an entire team there if they're not needed. But it also gives the public the assurance of knowing when do they need to block out time in their own personal calendars to be able to attend or log in for one of these hearings. Any questions, Karen, that I should address before I go on?
Yes, I have several.
Okay.
So during COVID times, how can we adequately get public comment? Using a chat function or written comments before the hearing seems not fair. What are others doing to make it fairer?
That's such a good question. I have to tell you, I actually think it's going better with COVID. And I didn't think I would say that. I was really worried about it. I think that people, for one thing, I'm seeing many more people actually sign in for these meetings than I would see at hearings. And I've been to some hearings that are very well attended. But it's not always convenient for parents with young kids to go out to a public hearing at night. So I'm just seeing generally more people signing in on these meetings. Most of the boards I work with use Zoom webinar to run the hearings. So when there's a point in the process where the public's questions are entertained, and the board chair or someone will say, so, if you want to speak, raise your hand. And whoever is hosting or helping to run the meeting is tracking in the registration list who has a hand raised. And then the questions are taken one by one. So people have an opportunity to ask questions. I have not seen a problem with it. And I didn't expect to say this to you. If you had asked me this question 4 or 5 months ago, I might have cringed. But now, having been through this a lot, I actually think there's a lot of merit to using remote participation for these hearings. The other thing that can be helpful to the board is that when a large group of abutters shows up at a hearing and they're wound up, and you can understand why, there is a tendency, even if they're asked not to, for people to applaud when a neighbor gets up and says something negative about the project, and to make unhappy noises when the developer responds. And that's not helpful to the ZBA. It really isn't. And so one of the advantages, I think, to the board in having remote participation is that all that noise, that background noise, kind of goes away, and you're hearing the question and you're hearing the response. So I don't think remote participation has been an issue, except, I will say this, most of the towns I work with have been at this long enough now that they know how to use Zoom, basically, or GoToMeeting. Those are the ones that I tend to see in use the most. They kind of get it, and the boards have been trained, and it all works fine. Some towns I worked with simply never missed a beat. They just moved from face-to-face meetings to online meetings seamlessly. Not every town has been like that. I have one board in particular that I service as an MHP consultant that has had tremendous difficulty managing Zoom, despite the efforts of the local planning director to train the board and to train the public. So I can't say that it's been a universal success. I think that in some communities, the boards need a lot more support than others. In that particular town, they tried to have just the board in a very large room with the applicant on Zoom, the abutters on Zoom, everybody else is on Zoom, but the board at least is in a room together, way spaced out, just so they could look at the plans in their hands. And that seemed to help some. But I would just say, I think that there is a lot of patience required, both on the part of the public and the applicant, that some of these boards simply have not had much experience with remote participation. And if it's a board that usually doesn't deal with any of this stuff, and perhaps their whole workload is reviewing decks on somebody's non-conforming house, and now all of a sudden they're hit with a 40B, you add the difficulty of just becoming familiar and comfortable with the 40B process on top of, oh my God, I have to do this remotely. It can be a real challenge. But I cannot say overall that it's unfair. I really feel like people, at least in the towns I'm working with, have had ample opportunity to comment. It's just more structured and managed by the board.
That's great. Okay, next question. We received the eligibility letter and full application as part of our review packet. In review, we find multiple errors in the application and applicant information provided, and it appears the pro forma information is skewed and not being checked. What can we do about this? In some cases, the project details in the ZBA application are different than what was reviewed by the state.
So I've seen this too. How do I say this? I think I'm going to continue to say, no matter what you think about the application, you open that hearing in 30 days. So I'm going to start there. You should do a completeness review in the very first hearing, like what's missing, so the applicant is on notice that that the application is deficient. I would say this, I don't know what town this is. I don't know what your rules and regulations say. I don't know what your application looks like, but I can tell you my experience is if you have an application form that is geared to a 40B and has attached to it specifically the stuff the developer has to submit, you have many fewer errors in the application process than you do if the developer shows up at the building department and nobody knows what to give them for a comp permit application format. So that's one issue. I have certainly seen my share of what's in front of the ZBA does not match what the subsidizing agency apparently saw. My experience is that unless it's really egregious, the subsidizing agencies don't reopen project eligibility. They will defer to the board to run the hearing, to make a decision, and if there's an issue, they deal with it in final approval later. I don't think once the comprehensive permit process is started, really, I think the subsidizing agencies don't want to appear to be getting in the middle. So you may see some differences, and they can be annoying, and you should ask the applicant why. And you should ask the applicant to correct their application. I mean, all those things that you would expect to do as a responsible board, you should do. And you can continue that hearing until they give you a complete application. So don't let them run roughshod over you, but it doesn't work to go back to the subsidizing agency, at least in my experience, and say, did you know X, Y, or Z? You've opened the hearing, they're going to step back unless it's something really egregious. I think too, I will talk more about the pro forma in a bit, but you shouldn't even be looking at the pro forma up front. For purposes of getting into the application review, it is irrelevant. And frankly, most of the pro formas I've seen, I wouldn't put a lot of stock in them. The pro forma that matters is one that comes later in the process if you ask for it. So you probably have seen discrepancies, but you have to keep going with that application process once you've opened it.
And here's one in a similar vein. How do you handle a presenter that is giving misinformation in the presentations and not supplying information that is requested in what appears to be stalling for time to run out the review deadline? Should we be contacting DHCD or the Housing Appeals Committee?
No, because they don't have a role yet. Housing Appeals Committee doesn't have a role until the ZBA has made a decision and filed it with the town clerk, and then only has a role if the developer appeals to them. I've had a few, for the most part, I should just say this. Most of the projects I've been involved with, the applicant eventually does respond to all the comments that have been made. You may not like the responses, but they will generally try to make sure they've covered everything because they don't want someone saying later, we had these comments and they didn't respond. As for whether something is accurate or inaccurate, I think if you're going to say it's inaccurate, you want to make sure you have accurate information to counter with. I mean, what is your source? So, for example, if an application contains errors and the peer review consultant has identified them, the applicant should correct them. And sometimes what you have to do is ask your peer review consultants for assistance with writing conditions of the permit that will essentially correct errors the applicant has refused to address. But I would just say, if you're going to challenge the applicant's veracity, make sure that you've got good source documentation.
Okay.
That may not be very helpful, but that's the best answer I can give you without knowing more details.
Okay, next question. How is, quote, production met, unquote, measured, built or approved?
So if it's a I will actually get to that in a later slide too, but just briefly, if it's a comprehensive permit, the units become eligible for the SHI when the decision's been filed with the city or town clerk. If they are not under a building permit, if they're not under construction within a year, those units will come off the SHI and be restored later when there is a building permit.
Okay.
So with a comprehensive permit, it's the decision's been filed with the town clerk or city clerk.
Okay. Should you open the public hearing even if you don't receive the project eligibility letter?
Oh, this came up in another town, and I think actually it is still in front of the HAC. Katie Lacey may have an update on this, I'm not sure, but I don't want to put Katie on the spot, but there is a case, or at least was a case until very recently, of a town near where I am that decided they had met safe harbor and didn't open an application. And there's a dispute now about whether they actually were at safe harbor. So they didn't, just town council told them to open the hearing. Town council was very clear, open this hearing and deal with it later. And they did not. And so now there's a dispute over whether the developer is eligible for constructive approval. So I'm just telling you, open the hearing. I don't care. I mean, I shouldn't say this, but you know, it could be the crappiest application you've ever seen. If it's been filed with the town clerk and it's been filed with you as a ZBA, you open the hearing in 30 days and deal with the problems once the hearing has been opened.
Katie, do you want to add anything to that? You're there. You're unmuted, but I can't hear you.
That's happened to me sometimes with GoToMeeting.
Okay, we can move on.
Okay.
Sorry, Katie. One more question? No, we have a couple more. There seems to be a new trend that once the project receives ZBA approval based on negotiation, the projects are coming back at later dates for the negotiated items to now be included as an insubstantial or substantial change. So how do you handle negotiated items so that this doesn't occur?
Well, it might occur anyway.
Hmm.
This answer is not going to make anybody happy. I can tell you, sometimes the developers will just say whatever to get their approval. Sometimes they genuinely think they can meet a requirement or condition that you want to impose. And it isn't until they get into more detailed site investigation that they find out that perhaps something you wanted isn't feasible. This has happened a couple of times on projects I've worked on in a town near Boston where frankly half the town is on ledge. And the applicant had not done you know, borings or anything prior to the permit. They didn't have to. They were able to basically go on existing available data. And so they agreed to certain things and then discovered when they started to now spend more money on the permitting process that it wasn't feasible to do some of the things they had agreed to do with the board. And the board had a tough situation on their hands, but they didn't really want to deny the project. So in the end, in a couple of cases, they negotiated some, some trade-offs, if you will. Bear in mind, of course, if the applicant comes back requesting an insubstantial change, the only matter in front of the board is the change and not the whole project. But I haven't seen a lot of what's being mentioned here, but I've seen it some. That the developer will come back and, I can't say that it's because of bad faith. I just know. You have to understand that part of what this process is about is how do you get the developer a legal permit with the entitlement he or she needs, spending, frankly, the least amount of money. So it's really after the comp permit process that this more detailed work gets done that has to be done to satisfy both the subsidizing agency and also get the plans to the level that they're buildable, or rather I should say, ready to file for a building permit. So a lot more goes on after the comprehensive permit process that the board hasn't seen, and it is sometimes in that effort to now get construction ready plans that the applicant will discover things about the site or whatever that they simply didn't know because they hadn't done those site investigations at the level that perhaps if they had, they might not have agreed to whatever they were asked to do. So it does happen sometimes, but it hasn't been a big problem, at least in my experience.
Okay, Judy, I have 5 or 6 more questions. Do you want to get through your presentation first?
Why don't I go
don't
a little farther because some of this, rest of this might answer those questions.
Okay.
Okay, why don't I do that? So technical review services, the ZBA is entitled to request. Of course, they have to be reasonable and relate to the board's authority. So typically the board will get a peer review consultant who's doing like site civil engineering review, stormwater, traffic, wetlands, especially if there's a local wetlands bylaw involved. And for larger multifamily projects, I always advise my ZBAs to get an architect because I think that design review can make a huge difference in the outcome of some of these developments. However, the board is going to hire their peer review consultants. It should be explained in the rules and regulations. Technical review is review. It is not new studies commissioned by the town. So you're reviewing the application that's been given to you. And of course, this is all paid for by the developer who provides funding that goes into an escrow account. The board hires whatever consultants they want to have, and then they're the ones who are approving payments or approving invoices from the peer review consultants. The developer doesn't have control over that. So the board has jurisdiction over comprehensive permits, but as I've tried to say earlier, assistance from the planning board and other boards really matters, especially if it's coordinated with peer review consultants. So the plan review, the design review, when you've got peer review consultants helping you, it is sometimes a good idea to at least make sure they touch base with some of the other boards and commissions that would normally be involved in permitting some of these projects if it wasn't a 40B. And also if they're boards that are going to be providing input to the ZBA. The more you can kind of make the consultants touch base at least and communicate with the other boards, the more likely it is that you're going to get a coordinated review with without a lot of inconsistencies between what the peer review consultant is saying and what the other boards are saying. That's not a guarantee, but I just find that good communication generally makes people feel better and feel like they're being heard. Also reduces the possibility that the ZBA is going to get conflicting testimony. Planning board, conservation, board of health staff, and others, should be participating in the technical review, as I said, coordinated with peer review. If your town already has a process for a technical review team, like at the staff level, reviewing projects before they go before the boards, use it for the 40B as well. Staff can sit down with the applicant and kind of go through the project, and oftentimes, the staff can identify things that may be incomplete or wrong in the application, and the applicant can kind of address them before it blows up with the Board of Appeals. If it's a project that's going to have work sessions, some towns do these and some don't. Those are basically meetings about the project, not a public hearing, but kind of a meeting that sort of gets into technical nitty-gritty stuff that nobody makes a decision, but there's a discussion about something that maybe has been a sticking point in the public hearing process. So you have staff, peer review, the developers folks meeting to kind of work those things out. It gets reported back to the ZBA, and then the ZBA can decide whether they want to accept the recommendations of the work session participants. But some towns do work sessions and some don't. If you do that, having the town staff involved is key. The other thing I think that town planners, city planners in particular, can help with is public education. Because so much of what happens in these processes that makes them difficult for the ZBA is mythology. The things that people think about affordable housing, think about people who live in it, who maybe don't understand planning work that's already been done at the town level to provide for affordable housing. If people aren't kind of in that loop, the town staff can play a very helpful role in at least making sure people have information. They may not like the information, but at least they have it. one of the things that I've seen that's extremely helpful to ZBAs is that as part of the review process, getting input from the housing trust or housing partnership or whoever happens to be active in your community. They normally don't get involved in project review, but they should be involved in comprehensive permit review. They can at least inform the board about the housing production plan, which the ZBA may never have seen, may not even know about. We have a housing production plan. What does it say? We have done a needs assessment. These are the needs that exist in our community. The project might help to address those needs in the following way. Is the site generally consistent with principles that we use to identify good locations, whether it's in the housing production plan or the master plan? Somebody needs to be a voice that's helpful to the ZBA thinking about how the project addresses housing needs. And that is not a role that typically a planning board or a board of health would play, but it is something that housing trusts do. So make sure that they're included in the review process to the ZBA, so the ZBA has the benefit of their input. As I said, some towns have work sessions. They're really to deal with, like I said, some technical matters that might come up in the hearing. Rather than getting the hearing sort of bogged down in them, you can have this meeting. It's not intended to sidestep the hearing. It's really to just be able to have a conversation that doesn't take up 2 hours at night of the Board of Appeals time. And then whoever is sort of in charge of organizing the work session can go back to the Board of Appeals and say, we met on such and such dates. This is what we discussed. And here are what we recommend that you do based on what we learned in those work sessions. And the ZBA gets to decide whether they want to accept those recommendations or not. Nobody steps into the role of the ZBA at any point in this process. It's still the ZBA's decision. I will tell you that some communities routinely do work sessions, some do not. If you have any question, it's a good idea to check with your town council, because some town councils do not approve of work sessions, which is perfectly fine, but know where your town council or city solicitor stands on it before you try to arrange a work session with an applicant. Applicants are responsible for telling you the waivers they need. It's not your job to figure that out. If they haven't done due diligence and gone through your local regs and figured out what waivers they need and why, then it's not your problem if they don't ask for the waivers. The waivers should be reasonably specific, like, you know, it's this section of the zoning bylaw we can't comply with, and here's why. Example, you know, your height limit's 35 feet, our building's going to be 48 feet. That's why we need a waiver. We need a waiver of your height regulation. They don't get to, they may ask you for what we call umbrella or plan waivers. You don't have to give those. A developer who comes in and says, I want to have a waiver, a blanket waiver from your local wetlands bylaw. You don't have to grant that. They have to do the work of telling you what waivers they need. I've had situations where they just throw in like the local wetlands bylaw and say, well, we can't meet this. But then you actually start talking about the application, you realize they do meet the local wetlands bylaw. So why do they need a waiver? I mean, just don't be afraid to kind of push back and get the level of detail you need to make a fair decision. You know, don't go overboard, but let's make sure the applicant provides an answer as to why they need a particular waiver. You know, you may, this is what came up before, you may get a request back from the applicant after the comprehensive permit is issued to make an insubstantial or a substantial change, because now they've gotten into preparing detailed plans and they have found out that something they didn't ask for in the first place, now they know they need. So they may come back and ask for an amendment to the comprehensive permit to provide additional waivers. It's not uncommon. And it's not necessarily because the developers are sloppy. It's just the phase of the project development process that it's in when the development application is in front of the ZBA, as opposed to preparing plans for the building permit. The ZBA process will work best if you focus on certain things. Everybody wants to talk about density. It's almost unavoidable. The statute doesn't consider density a valid local concern. It does consider design a valid local concern. So if you have a design review board in your community, you're probably going to want to include them in the review process. If you don't, and even if you do, getting an architect to provide independent advice to the Board of Appeals, you'd be amazed at how you know, changing a roof structure can change the whole appearance of the height of a building. And sometimes developers can make significant design changes that improve the building, and they don't lose any units at all. Sometimes they do. But the objective should be the best quality project, not the smallest. The statute doesn't say that you can't grant waivers the statute says you have to grant waivers that are necessary to make the project feasible. But you get to negotiate with the applicant, and if getting a nicer looking building or a building that fits better in the neighborhood, and they don't lose any units, who cares? The point is the better project, not the density. And also to make sure you're looking at the site plan. I can't tell you how frustrating I find it. Katie's probably going to want to shoot me for saying this, but so many times I'll see a site plan that's in front of a comprehensive permit, in front of a Board of Appeals, and it's covered with parking. And everybody thinks that there's going to be a zillion people in this development, especially if it's rental, and there's never enough parking. Well, you don't want to build a gray field. You actually want to provide adequate parking. But people have ideas about what multifamily needs. It's usually out of whack with reality. What really should matter is there green space on the site? Is there a place where somebody can walk outside the building and at least get some relief from hardscape? What do you have in terms of, I'm not necessarily saying trails and so forth, but do you have, small like pocket park type areas on the site where people can go and enjoy the outside? Are there areas where residents can congregate and be together as a community? Those things matter. So, you have to be careful that you're not asking for so much that you now render the project uneconomic. But look at ways that you don't have to ask for a zillion parking spaces per unit, because sometimes you can give up some parking and get a very nice site plan. Make sure public safety personnel look at these projects as early as possible so that you have that input. If there is a problem with site access, with site circulation, you want to know that early on so that if there are changes that are needed to the plan to make it safer for the residents and for other people, who might be passing the site, you're going to want to deal with that stuff early on. And again, what are the waivers that relate to environmental resources? Which ones can you accommodate and which ones are essentially deal breakers? And those deal breakers shouldn't be everything, because frankly, not every local regulation is as essential as the next one. So having some understanding about what's really critical matters. And the whole point of this review, again, is not to shrink the size of a project. It may need to be reduced. I'm not saying that they're all right. I'm just saying that when you start there, you actually end up tying the board's hands in terms of maybe getting a better project. That sometimes density just isn't the issue, it's a crappy design. And so it's a site layout that just doesn't work. But if they make some changes to the site layout, if they think more carefully about the exterior building materials, and perhaps the massing of the building, maybe you got a better project, the developer gets the units he wants, and then everybody wins. So what's the problem? But the focus needs to be, how do you get the best project you can? There is no such thing as an automatic pro forma review. Years ago, CPAs would jump to the pro forma before the public hearing had even opened. Doesn't work that way anymore. You go through the process and review the application on qualitative terms. If you get to a point in that process where the board feels really strongly about a change that the applicant should make to have it a better project for the town, and the applicant says, I just can't do that, you're going to make my project uneconomic. At that point, you say, give us a pro forma and prove it. So the applicant comes back with a pro forma that shows whatever the conditions are the board wants to impose. And of course, the pro forma is likely to say he can't do it, the developer can't do it. It's at that point that the board engages an independent peer review consultant to review the pro forma. Until that, because you may ask for a bunch of changes and the applicant says, fine, I'll make them. But you don't need a pro forma review. If you do, then it's based on changes you are requesting to the project that the applicant says, for whatever reason, they can't do. So you retain an outside consultant to review the pro forma. I will tell you that my experience, for whatever it's worth, is if you can avoid this, avoid it like the plague. Because the worst position the ZBA can be in is You go hire a peer review consultant. And what do you do when they come back and say the applicant's right? Now you've lost your leverage. So it makes much more sense to try to get everything you can out of the applicant for the best project you can possibly extract from them. And if all else fails, then you go to the pro forma review. But if you start with that out of the box, you're really hampering the board's ability to get improvements to the project. So you sort of have this diligent kind of scheduled review, traffic, environmental design, you schedule these different things, these different topics at different nights, and you get to this point in the process where you say, okay, we think we have a handle now on what we really have a problem with this project. Here are these 3 things we have an issue with. Can you address them in the following ways? And often it is actually the board asking for fewer units, but you don't start there. And so you ask the applicant, can you make these changes? Sometimes the applicant will say yes. So if they don't, that's when you start to look into the peer review, the pro forma review. So I'm saying this now because whatever's in the application, frankly, I don't even pay attention to it. I just don't. It's not worth it. What matters is, can the applicant do what you're asking them to do? This is something that sometimes ZBAs are under pressure to address in their decision. Frankly, I don't consider it a comprehensive permit matter, but I want you to know what the rules are. There is a provision for towns to request local preference for access to new affordable units, ownership or rental. Local preference means that if a person is living in your community when the notices are available, there's new affordable housing available at the following income limits, 1, 2, 3 bedroom units. Here's how you apply. If they live in the town when the application process begins, or if they work for the town, live somewhere else but work for the town, or work for a local business when the application process for the units begins. Or if they live outside of town but their children attend the local public schools, which is sometimes an issue in the communities close to Boston that participate in what's called the METCO program. But it's not only METCO, it can be children who are in a special needs collaborative, and the collaborative class happens to be in that particular town. Those are the eligible local preference categories. Do you live in the town now? Do you work for the town now? Do you work for a local employer now? Or do you have children in the public schools now? So you can't limit it to people who've lived in the town for some period of time. It's based solely on their residence, employment status, or school enrollment at the time of the lottery for initial occupancy. Towns can request up to 70%. It's not guaranteed, although my experience is usually the state will go ahead and approve it if a reasonable argument can be made that there is a need in the community that this particular development will address. The board has 3 options under Chapter 40B. It can deny the project, it can approve it with conditions, it can approve it as is. Most of the projects I've seen end up being approved with conditions, which may or may not be acceptable to the developer. There's a big difference between denial and approval. So generally, I think most attorneys and most consultants suggest to boards, if you can possibly do it, approve it with conditions. Because a denial basically means the whole project is now subject to a threshold question at the Housing Appeals Committee. Do you meet one of those statutory minima? And if you don't, it just becomes, it's almost impossible, frankly, to overcome the denial. It's not impossible, but it's very, very difficult. It's more likely that if you go into the hearing process with the HAC with an approval with conditions, you might have some of those conditions survive, or maybe the entire permit survives. Typical structure of a decision. This is kind of standard if you guys are on planning boards or ZBAs. You might be used to some of this. There's some procedural history. Application came in on X date. Consisted of the following plans and drawings. Applicant is so-and-so, the address is whatever. So you go through the whole procedural history of like all the different hearings and kind of what happened. And then there's a section on governing law. This is sort of like, well, here are the legal standards that we have to apply to this case. What are the findings of fact? So we have all this information we've taken in. We have to review that information in light of the law. What facts do we derive from that information that are within the confines of that law that we are able to consider? Here's our decision, yes, no, or yes with conditions. Here are the conditions. There are typically exhibits attached to the application. Often the waiver list goes there. It's just easier to kind of tack on at the end. There's also what we call kind of a side monitoring agreement that basically provides for some amount of money from the applicant to make sure the project is monitored once the subsidizing agency's role in reviewing and enforcing the affordable housing restriction has ended. So there's got to be a way to kind of continue to monitor the project. And that ongoing monitoring agreement is typically attached to the comprehensive permit. So that's basic structure of a comp permit decision. After the permit process, the applicant has a lot more to do. And you may never see any of this unless the applicant has to come back for a substantial or an insubstantial change to the permit. Subsidizing agency really takes over at this point. There's a phase called final approval. The project is really kind of reviewed at a much greater level of detail at this point. Does it make sense in the market where this housing is going to be built? Does this developer know what he or she is doing? Does the developer team have adequate capacity to manage the project, etc.? There's also an affirmative fair housing marketing plan that's required, which outlines how the applicant is going to make units available to people who are income eligible to apply, given units that would be suitable for the household size and composition of those households. So how are you going to reach out to families who need 3-bedroom units? How are you going to reach out to single people who need 1-bedroom units? The whole plan kind of gets really granular as to how that outreach is going to take place and how the tenant selection process will be handled. Oversight of construction and occupancy, and then all those sort of post-occupancy requirements around monitoring. It's really the board's job is really that permit that gives the entitlement to the developer to proceed. And then much of the rest of this kind of falls in the hands of the subsidizing agency. Of course, clearly when the project's under construction, the building department or whoever is going to be, overseeing it as well. And if it's a large project, the applicant really should give some money to the town or city to make sure the building department has adequate resources to perhaps bring in a couple of consultants to help with, say, multifamily review for large buildings if the building department doesn't have that capacity. So a lot happens after the comprehensive permit. I'm a planner, so I need to just really underscore this. Planning really does matter in this business. If your town doesn't have one, it's a good idea to develop a housing production plan. Make sure it's realistic. Sometimes I've seen housing production plans that really were not realistic to begin with, or were not really based on solid information. So, have a good housing production plan that actually crafts a realistic strategy for you to work toward that 10%. Because if you meet the numerical targets that are required in the 40B regulations and the housing production plan guidelines, your town may become eligible for what's called certification, which means really you've produced a certain number of units. And that gives the Board of Appeals much greater latitude to decide what to do with a comprehensive permit while the certification's in place. So making the plan is the first step. Seeking DHCD's approval is the next step. And then actually producing units is what gets you to certification. The plan itself doesn't do a lot for you unless you're actually producing. There are other plans, though, that come into play. I mean, certainly a town's master plan or comprehensive plan. Under Massachusetts law, Chapter 41, Section 81D, master plans are required to have a housing element. And one of the things that your housing element should look at is the needs of people with low or moderate incomes. Does your town have a capital improvements plan? Maybe that will help to shed light on infrastructure impacts that the applicant needs to either address through the project development process, or perhaps in terms of some kind of contribution to a, stormwater fund or something. If you're going to, understand what the capacity of your municipal facilities are, not to hang an application on it, but rather to understand that you have an obligation, like every other city and town, to have at least 10% of your housing for lower moderate income households. And so if there are issues, if you're anticipating issues with your school space, you need to be addressing that as a town, because you have an obligation to provide a free and appropriate public education to children who live in your community. That's not itself a reason to deny a comp permit. So planning really can help you manage impacts, not only of 40Bs, but other types of development. I just can't say enough for this. Planning really, really matters. It helps communities get much better projects if the planning is thorough, if it's professionally prepared. That doesn't necessarily mean you have to hire consultants, but if people who prepared the plans know what they're doing, and if they're realistic, those things all matter. I want to just talk briefly about this concept of local action units. This is another way to create housing that is eligible for the subsidized housing inventory that you can do without having to deal with comprehensive permits. So these are units that are built outside the comprehensive permit process. They don't need a 40B approval from the Board of Appeals. They're built under some type of local action, something that the town or city did. For these projects, for these units, DHCD is the subsidizing agency. Local action units are part of what's called the Local Initiative Program, which goes way back to the early 1990s when it was kind of originally created. LIP is a device for creating comprehensive permit projects that are that kind of involve the town more upfront than is typically the case with other types of comp permits. But the LAUs are part of the Local Initiative Program. So the staff for LIP, so-called, at DHCD will work with your town on the local action units process. And the units are eligible for the subsidized housing inventory if they meet DHCD requirements. So local action is typically the result of something in your zoning bylaw or ordinance. Say you have an inclusionary housing bylaw that encourages developers to create affordable units because you give them some additional density for doing so. You know, additional market rate units perhaps for providing some affordability. Or you allow housing above commercial space that if it includes some affordable units, things like that, that you're taking an action as a city or town to create affordability where perhaps it otherwise wouldn't have happened. It is often the condition of a special permit, although frankly, you can create affordable housing in your zoning without a special permit, but it typically involves some kind of special permit decision. Sometimes LAUs are created by donations of municipal land for, say, Habitat for Humanity or some type of nonprofit developer to do a more significant project than a unit or two. Sometimes affordable housing that is eligible as an LAU is created with the use of things like Community Preservation Act funds or other sources of money. The point is that the community is doing something proactively to create those units, either through a regulatory way or a subsidy way. Subsidy, of course, including a donation of land. These things work if they're feasible and you're flexible and you're fair. If all of those things exist, local action units can be created. They are created. We have communities in Massachusetts that have done a good job with local action units production because whatever their program was, whether it's a zoning regulation or a subsidy program run by a housing trust, it hit all three of those points. It was feasible, it was flexible, and it was fair. The units, of course, have to meet all of the basic SHI requirements to count. So they will be affordable based on income limits that are set every year. As I said earlier, income limits that are set by HUD and adopted by DHCD and used for the 40B program. If the units are subject to a cost limitation that ensures their affordability, they are subject to an approved affirmative fair housing marketing plan. So LAUs, just like any other affordable unit, have to be available to people without regard to race or color or creed or religion or sex or what, all of the populations that are protected under the state anti-discrimination law. There's a regulatory agreement that kind of locks in the affordability at the deed level so that you know there's an enforceable way to protect that affordability over time. And then someone's going to monitor those units, and who is it going to be, and what does that provision look like? Kind of like with a conservation restriction, somebody has to, monitor and enforce it. It's the same with an affordable housing restriction. In order to act on your request to add LAUs to your subsidized housing inventory, DHCD needs to know what was the local action that you took. What is the zoning bylaw or ordinance that enabled this, if it in fact was a regulatory device? Give us a special permit decision so we can see what you said in it. Because naturally they want to make sure there isn't stuff written into the special permit that would have the effect of being discriminatory in some way. If it's development of municipal property, they at the very least want some evidence that the town actually controls the site. There needs to be a long-term affordability restriction. As I said, if the project is assisted with federal home funds, there will be a home covenant or deed restriction in place that's governed by that program. If you're going to want to suggest any modifications to DHCD's standard regulatory agreement or affordability restriction, you submit it with your LAU application marked up so that DHCD can see what you want to change. And ultimately, it has to be approved by the developer, the town, and DHCD. They're all party to this agreement, which then gets recorded with the registry. And eventually you have a unit that, that will qualify for the SHI. So these are kind of all the steps that are involved. Is kind of, first of all, you got to build local support for that local action, whatever it may be, to kind of take that local action, you know, work with DHCD and make sure that your local permits or approvals or whatever they are that's enabling that unit are in place so DHCD can review them. You build the housing, the households move in, the unit counts, and then, of course, keeping it on the SHI because you or some other entity are properly enforcing the restriction. So it is possible to do this without comprehensive permits. We have a couple of towns in Massachusetts that I know of that are over 10% and have never issued a comprehensive permit to get there. So it is possible to do. It takes a lot of work, but it can be done. So at this point, Karen, I'll take whatever questions have been piling up there in the list as I've been.
Okay. Can you choose not to waive a local conservation law for wetlands? Information you presented regarding conservation seems to imply local has to be waived since developers only need to comply with state regs.
No, I'm not saying you have to waive it. I'm saying that the decision goes to the Board of Appeals, whether to waive it. So the applicant has a duty to tell you why they need a waiver of the local wetlands bylaw, assuming one exists. So if it's in their waiver list, if they're just asking for a blanket waiver of the local wetlands bylaw, you shouldn't grant it. If they say they need a waiver of the local wetlands bylaw because under the local bylaw, you have a no build provision that's significantly different from perhaps the state law, you know, you have to ask this question for every single waiver. Does this outweigh the regional need for affordable housing? That's the balancing test the Board of Appeals has to do. So, you know, in most cases, I have to tell you, the answer will be it doesn't outweigh that need. If it does, then you don't grant the waiver and then let the chips fall where they may. And the developer may say, fine, I'll live with it or not. I'm never going to tell some board to just grant whatever the developer wants because it's a 40B. I mean, you don't have to do that. I'm saying you have to be fair and you have to be realistic, and getting input from the Conservation Commission can be helpful. The other thing you should do is make sure your peer review consultant reviews those waivers and provides advice to the board. Sometimes it's hard for a local board to say it's okay to waive our regulations, and you can certainly understand that. But the peer review consultant may be able to say, you know, these certain local requirements really they're deal breakers. But this one the developer's asking for is not such a big deal. And so that's what you have peer review consultants for, is to help you think through, are these fair and reasonable requests of the developer? And are they more important than the regional need for affordable housing? And if you think they are more important, then you don't grant the waiver.
Sounds reasonable. Can you recommend a comprehensive permit requirement list / form from a town that has a thorough one?
Yeah, I can. I mean, is my email address somewhere? I mean, can we maybe put it in the chat or something and people could just email me?
Sure.
Yes, I can. I've seen a couple. I have to tell you, most towns don't do this until they get slammed with several 40Bs and all of a sudden they realize that developers are trying to fill out a special permit application and halfway through it, they're just writing not applicable, and it just, everybody gets frustrated. So no reason to do that.
Also, Judy, do you provide these slides to CPTC?
Yeah, I will send you guys, I guess, a PDF of the slides.
Okay. Is an applicant required to market the project as presented and approved prior to marketing it with changes not yet approved?
Well, the CBA doesn't get involved with approving a marketing plan anyway. That's not in the CBA's jurisdiction. It's with the subsidizing agency. So, I mean, in a way, it kind of helps the board. There are things the Board of Appeals just doesn't have jurisdiction over. And it's probably just as well that they don't, because then they don't have to get involved in some of this stuff. But the marketing plan is reviewed and supervised and monitored by the subsidizing agency. You know, so it's their problem if something doesn't go the way it's supposed to.
Does adopting MGL Chapter 43D count as local action towards LAUs?
If the 43D priority development site regulations at the local level enabled the creation of a unit, I don't know why not.
Okay.
I mean, usually 43D is about sort of procedural waivers so that an application can be processed within 180 days, ironically, 180 days. You know, that's typically what the intent is. So I guess it would depend on how the 43D process at the local level enabled the creation of those units. 43D itself doesn't create new regulations. It's a process for consolidating and streamlining the reviews.
Can you supply a copy of your suggested public hearing protocol?
Yeah, I'll send that out. Again, anybody
Okay.
who contact me through email, I'll send you this stuff.
Okay. And Katie wanted to mention, I don't know if everybody's read this, that MHP provides free 40B technical assistance. I know before my job at the regional planning agency, I worked for a municipality and we used their technical assistance and it was excellent. They provide consultants just like Judy and they guide you through the whole process and it's just fantastic. So I highly recommend that. And Katie and I both posted the link to the handbook, the 40B handbook. What else? This one concerns me. Our town is afraid of Zoom bombing, so they do not allow the public to speak. Can the chair of ZBA overrule this town policy?
So you can't run a public hearing and not allow the public to speak at all. There has to be an opportunity for the public to address the board. My experience is that to address Zoom bombing, towns are using Zoom Webinar, which is a slightly different license from regular Zoom. And through Zoom Webinar, you really can prevent Zoom bombing. I mean, somebody has to be managing the allowing people in and out of the meeting, you know, so that if someone starts to behave in inappropriate ways, they can just be shut off. But Zoom Webinar is a more effective way to manage that, in my experience.
I think I got most of are your 40B hearings on separate nights? Yes, I would, yes.
Yeah, you mean separate from regular ZBA business? Do you think that's the intent of the question? Because
That may be the intent.
yeah, so if a ZBA isn't real busy, sometimes they'll try to accommodate these in their regular schedule, but for the most part, I tend to see them on separate nights.
Someone, Lakshmi, said, can you please post the 40B handbook link? It is in the chat somewhere, way up at the top or halfway down. And I just posted Judy's email address. And
Yeah,
I
so
think
go ahead, I'm sorry.
sorry. Go ahead.
I'm just gonna say, if anybody can't see in the chat easily those links, if you just ask for them, I can actually put them in my email as well.
Okay.
Every email response back to anybody who asks for them.
That's great. If you have nothing else, I think that's it.
Pretty good.
Yes, that was excellent, Judy. Thank you so much.
Thank you. Thank you very much.
And thank you everyone for joining us.
Yeah, and if anybody contacts me, I will get back to you. So no worries. Okay?
You don't know what you've gotten yourself into, Judy.
Oh, no, I've been through this before. It's fine. I've done this training before. It's fine. All right?
All right. Thank you very much.
Thank you. Have a good evening.
You too.
Bye.